Hasta la vista.
See you next year.
Well, good morning, everyone. Welcome to the concluding session of the 71st Annual Antitrust Law Section Spring Meeting. As I mentioned last night, and some of you may have heard, we're stressing the word annual. We went 2 years because of the pandemic without our gathering. We returned last year, and the declaration is we are here to stay, that if the pandemic could not hinder us, nothing will, and we gather as we have, and thanks to the over 3,700 folks who have convened for this meeting. And we've come almost to the end, and this is intentionally our last session of the spring meeting. As many of you have, I've got a lot of wisdom from my mother. And my mother said that at the end of the day, it is better to talk with than to talk about. And certainly there's been a lot of discussion about antitrust and consumer protection and data privacy, law, policy, practice. But we want to hear, as we always conclude, with the principal enforcers, and to hear from them directly as to what it is we should be paying attention to and looking for and working with. And so we're thrilled to conclude with this panel and to hear. I am, as always, all ears as we proceed today. And we hope you all enjoy this as much as I know I am going to. I will turn it over to my co-moderator, Nanette Adu, who will introduce the speakers and kick us off.
Thank you very much, Tom, and delighted to have you all here today. I'm also delighted to have the privilege to introduce our panelists today. Starting from my extreme right is Sarah Cardell, and she is the Chief Executive of the Competition and Markets Authority. Sarah also previously served as General Counsel at the CMA. Next to Sarah is Gwendolyn Cooley, and she is the Chair of the National Association of Attorney Generals, the Antitrust Task Force, and she's also the Attorney General for Wisconsin. To my immediate left is Jonathan Kanter. He is the Chair of the Federal Trade Commission, having served previously oh, I beg your pardon, Attorney General.
I thought we had breaking news.
Even better.
Shh, it was a
keep
test.
Going. Just keep going. You're doing great.
So Jonathan is the Assistant Attorney General for the Antitrust Division of the U.S. Department of Justice. And Lena Khan, she is the Chair of the Federal Trade Commission, having served previously as the Associate Professor of Law at the Columbia Law School. Last but not least is Margareta Vestager, and she's Executive Vice President in Europe, and she's also Commissioner for Competition Matters. None of them, of course, need any introduction as amongst the key actors for antitrust enforcement and also competition policy development. We thought we would begin our session by giving each of our panelists an opportunity to share with us their priorities, certainly for this year, but also looking ahead, talking to us about some of the policy changes that we as Antitrust Council, enforcers in other regions, and also academics are actually seeing. What I thought I might do is actually start in the order in which I introduced our guests, making sure that everyone gets an opportunity. So perhaps, Sarah, if you'd like to begin, please.
Thank you so much, and thank you very much for the invitation to speak today. It's fantastic to have the opportunity to speak with this great audience. So what I thought I'd start off with actually is just a little bit of background and context, because I'm conscious that perhaps there are varying degrees of familiarity with the work of the UK CMA in the audience. So the first point is just to say that the CMA is an integrated competition and consumer protection authority, and that's really important for us in the way that we work, because we do take a really joined-up approach to thinking across both competition and consumer enforcement when we're looking at the particular issues that we're seeking to tackle. But many of you, I suspect, will be most familiar with the CMA from an international perspective because of our role in relation to merger control. And I think it's fair to say that at an international level, the role of the CMA has gained greater prominence and greater interest in recent years. And there are two sort of principal reasons for that. The first is obviously the impact of the UK's exit from the European Union, which has meant that the CMA has greater competence in terms of looking particularly at the impact of many more global transactions and the impact of those deals on UK markets. And the second reason I think that the CMA's work in merger control has gained particular interest internationally is that there is, I think, at least a perception that the CMA is a particularly tough merger control authority. And I just wanted to spend a few minutes sort of exploring those a little bit, and then I'll come on to some of our broader priorities and areas of activity. When it comes to merger control, I think from a jurisdictional perspective, it's absolutely right and not at all surprising that the CMA is now looking at a greater number of global deals. Obviously, previously, many global transactions that had an impact on the UK would have been considered by the European Commission. But now it's the role of the CMA to look at mergers and to protect UK consumers and UK businesses from anti-competitive mergers. And that is a responsibility that the CMA takes very, very seriously. When it comes to jurisdiction, you may or may not be familiar with the particular jurisdictional tests that we have, but essentially the CMA has the ability to look at transactions either where the target company has UK turnover of more than £70 million or where the deal hits our share of supply test. And I think for international parties and businesses, perhaps there has been some surprise about the jurisdictional reach of UK merger control. But I really don't think this should be a surprise. If we boil it down to basics, what we are doing is looking closely at transactions which may have a material impact on competition in the UK. And that's our role, that's our responsibility. We apply the share of supply test in a fairly broad way, and that has been upheld by our UK courts, that there is a deliberate intent for the UK Parliament to make sure that the CMA can use that gating jurisdictional provision to give close scrutiny to deals that may impact on competition in the UK. And sometimes it's put to me, why is it the case that the CMA, that the UK Merger Control Authority, is looking at deals between non-UK businesses, two US companies merging? Why is it the case that the CMA has jurisdiction to look at that deal? And the answer is quite simple. If a transaction is hitting our jurisdictional thresholds, if a transaction has an impact on UK markets, then it's clear that we are empowered to look at that deal. And that applies to deals that may have a centre of gravity that sits outside the UK. So I don't think that approach should come as a surprise. What it doesn't mean, though, is that our approach to jurisdiction is unpredictable or arbitrary. We have very clear guidance about how we apply our jurisdictional tests. And one thing I think that's particularly important to emphasise, perhaps for this audience, is that there is a very clear and accessible process where businesses, parties who are unsure whether or not the CMA will look at a particular deal can put in a short briefing paper to our Merger Intelligence Committee and can get a quick and early view from us on whether this is the kind of deal that we're likely to review. So I hope that gives some clarity about our approach to jurisdiction and the way that we look at deals. When it comes to substance, I think we'll probably come on later in the discussion to a little bit more of discussion around our substantive approach to assessing mergers. But I did just want to sort of touch on this point about the reputation of the CMA as a particularly tough, or it's been put to me this week, a particularly aggressive merger control authority. And again, I think it's just really important to sort of take this back to basics a little bit. The CMA doesn't have a sort of predetermined anti-merger agenda, but as I said, we have a very clear statutory responsibility to look closely at mergers that may have an adverse impact on competition in the UK, and we will do that thoroughly and carefully. We will undertake a careful, considered, objective and evidence-based approach to reviewing each and every one of those deals, and we will reach a conclusion on the basis of the facts and the evidence before us about whether or not in a particular case it gives rise to in our test, a substantive lessening of competition. But as I say, that doesn't mean that we're fundamentally anti-mergers. We recognise that very many mergers don't create competition concerns, and indeed some can well improve competition. But we will look very closely at those deals. And one of the benefits, actually, of the UK regime, which is quite unusual, is that because we don't have a mandatory notification threshold, we also don't have to review many, many deals that don't have an adverse impact on competition. And that enables us to be, actually, I think, a very efficient merger control authority, where if you look at the number of transactions we review year on year, they're proportionately perhaps quite a lot smaller than in other jurisdictions that have mandatory thresholds. But it does mean that we tend to focus in on those deals where we can see potential competition concerns. And what does that mean overall? If you look at the stats over the last few years, it varies year on year, but on average we have either prohibited or required divestments in around, say, 5 to 6 deals a year. Now, I think that's a sign of a robust and effective merger control authority, but I don't think it's a signal that we are excessively aggressive. So just to give a bit of a framing perspective on our approach to mergers. Moving away from mergers for a minute, Brexit's actually had a big impact on a number of other areas of our work as well. So to give an example, we have some entirely new functions. We have a subsidy advice unit, which to some extent replicates the state aid regime that we used to be under when we were part of the EU. And we also, in antitrust, a little bit similar to merger control, we now have an enhanced jurisdiction. Obviously, historically, we used to have a shared competence with the European Commission when it came to antitrust cases. Again, the CMA now has sole responsibility for pursuing antitrust enforcement where that impacts on the UK. Actually, what I should say is that I think you will see many parallels in terms of the types of cases and the issues that we're taking on across the UK, across the European Commission, and indeed with the US as well. When we look at our antitrust portfolio over the last year, we've continued to have, and I think will continue to have, a very substantial focus on cases in digital markets. That's not surprising given the competition concerns that we see in those markets. To give a few examples of our current cases, we are looking at both Amazon and Meta's use of data. We have cases involving both Google and Apple's approach to their in-app payment systems. We have a case where we're looking at Google's position in the ad tech stack. And I think all well understood issues in digital markets. And our focus on digital markets isn't just limited to antitrust cases. So in the UK, we have the ability to undertake broader market reviews as well. And those have been a really, really important tool for us to be able to do quite a deep and thorough investigation of the competition dynamics and the competition concerns that we see in a number of digital markets. So a couple of years back, we completed a market study in relation to digital advertising. Last year, we completed one looking at mobile ecosystems. But in the UK, like in a number of other jurisdictions, whilst we are using our full toolkit to the fullest effect in seeking to tackle issues in digital markets, there is also a recognition that there are limits to that toolkit. And the UK government has proposed the introduction of a new regulatory regime focused on digital markets that will be more of an ex-ante regulatory regime, and it will give the CMA the ability to both designate and then regulate major platforms that have strategic market status in relation to digital markets. And that requires a somewhat different approach to historic antitrust enforcement. So we will have the power there to designate specific companies where they have an entrenched position of market power in relation to specific digital activities. And once those designations are complete, we will be able to do two things. First of all, we will be able to impose conduct requirements, which are really about managing the exercise of market power in those digital markets. And then secondly, we'll be able to introduce what we term pro-competitive interventions, and that's about tackling the underlying causes of market power. So, for example, introducing interoperability provisions. So that gives a little bit of a flavour of our key focus on digital markets. And then I finally just wanted to sort of close by taking a little bit of a step back and talking a bit more broadly about some of our priorities as an agency. And I think it's important in this kind of environment because whilst it's always fascinating to have really interesting discussions with antitrust practitioners, at the end of the day, what really matters to us as a competition agency is that we deliver impactful, beneficial outcomes for the people and the businesses that we are here to serve. So in the UK, obviously for the CMA, that's about us serving UK people, UK consumers, businesses, and playing our part to support the wider economy. So we've actually spent quite a bit of time over the last 6 months looking at how to frame our strategy with those objectives in mind, and really looking at the outcomes that we're seeking to deliver across those groups. And we framed that in a broad ambition to promote competitive markets and to tackle unfair behaviour. So I thought I'd just give a little snapshot of some of the examples of how we see that playing through in some of our cases. So when we're looking at the benefits that we're looking to deliver for people, we focus particularly on areas of activity of sort of core consumer need or core consumer harm, and really making sure that we're lasering in and focusing our efforts and activities in that space. So for example, we've continued a very substantial portfolio of work on the antitrust side, taking action against companies engaged in excessive pricing in core pharmaceutical products, and that's been a key priority for the CMA over the last few years. We've continued to complete and are now defending some of those cases in court. We've also taken action. We're investigating at the moment a case in relation to collusive wage fixing, which I think is really important, particularly in the current climate where household budgets are under so much pressure, and we want to send a clear signal to businesses that they shouldn't be colluding to suppress wages. And we're using our consumer enforcement powers, as I mentioned, so in particular tackling online pricing practices, things like fake urgency claims, and using consumer protection to tackle that. When we're focusing on businesses, I think sometimes there's a bit of perception that as a competition agency, you have to choose whether you're pro-consumer or pro-business, and I don't think that's the case at all. I think that there is no tension between the two. So we've made it very clear that as well as supporting consumers, our objective is to support fair dealing, competitive businesses, making sure that they can really innovate and thrive in the markets where they're active. And I think you can see that very clearly in a lot of the digital markets work that we're pursuing. And then finally, we do think that the CMA has a really important role to play more broadly in supporting the UK economy, particularly again at a time of economic pressures that we all see and recognise at the moment. One of the things that we have done actually is establish a new microeconomics unit, which is focused on really producing some very deep and thoughtful research, looking at the connections between competition, innovation, investment, productivity and growth, and really to try to sort of take forward that agenda and understand both how we can advise the UK government but also inform our own work in that space. And we've also focused on other themes, including supporting the UK's transition to a net zero economy and what we can do there. So I think hopefully that gives you a little bit of a flavour of the scale and the scope of our priorities and the kind of work that we're taking forward.
Thank you very much, Sarah. I'd like to pick up on a few of the points you've made. There are others that I'm sure we'll come to later on. One key question, though, it seems to me at any rate, that certainly post-Brexit, the CMA has established itself as a major player. You use the term aggressive. I suspect...
I didn't use that of myself. That term is put to me.
That is certainly true. But I think one of the questions that I think it seems to me that a lot of observers will ask themselves is, to what extent is it a concern, if at all, that there are sometimes significant divergences in the approach that the CMA might take in comparison to, for example, the EU or other jurisdictions? And perhaps if you would answer that question in the context of mergers, but you also touched upon digital markets as well. Of course, there's a lot of focus on digital markets. I'd be interested in your thoughts around that particular topic.
Yeah, I mean, I think my first point is that I think when I hear that argument, it's hugely overstated, to be honest. I mean, you will hear from other colleagues across the panel, but what I see day to day is first a huge amount of close working across agencies, and that can happen in a number of forms. That can happen both on individual cases and through broader fora. It happens both bilaterally and multilaterally. And I think it's certainly not the case from a CMA perspective that we see ourselves as operating in an international bubble. We are acutely conscious that many of the issues that we're looking at, whether, as you say, it's in relation to mergers or whether it's in relation to broader issues across digital markets, they are global issues, or they are issues that cut across a number of different jurisdictions. And there are many reasons in many cases to strive for an outcome that is aligned across those jurisdictions. I mean, I can talk about more detail in relation to mergers. We can cover that now, or we can come back to that later. But the sort of headline point I would make is that when you look at the cases where there have been international dimensions to those cases, where you've had a number of different jurisdictions looking at the same mergers in parallel, I think on process there's a lot of alignment and a lot of close working, and on substance and the substantive outcomes, in the vast majority of cases, I think you will also see that alignment. Of course, there will be some cases which ultimately end up in different outcomes, and I think that's only to be expected. And I would suggest in the majority of those cases, that will be driven by actually differences in the evidence across different jurisdictions. You may well have a transaction that's being reviewed in a number of different jurisdictions, but it doesn't mean that the competition assessment is exactly the same in those different jurisdictions. And of course, the processes and the procedures and the tests that we apply are slightly different in different jurisdictions. So at the margin, in a small set of cases, that may produce different outcomes. But I really don't think that there is a sort of fundamental difference and a fundamental divergence of outcomes.
Thank you for that. Gwendolyn, closer to home, what are you seeing as the priorities from the State Attorney General's level, please?
Sure. Well, we have a number of different priorities, and I will say, just to dial it back, actually, I would say for those with even a passing awareness of the United States politics who've watched the news in the last 24 hours, the idea that vastly differing attorneys general from vastly differing states would band together to prosecute antitrust cases seems like an unlikely alliance. However, our antitrust task force has shown that we are a resilient and formidable force in litigation, and one that will be spending much of the next year doing that. So for what is our priorities? At present count, we have 4 multi-state cases, or I guess 5, depending on how you count, that are set for trial this year. September, we have the Google search case, which is both the joint DOJ case and the Cone case, as it's called, Colorado, Nebraska. Also September, we have the case that I lead for the states, the Suboxone pharmaceutical product hopping case. Then in October, we have a newly scheduled trial, again, with my friend A.G. Cantor, and that is to block the merger, or attempt to block the merger of JetBlue and Spirit, and currently scheduled for November, the Google in-app payments case led by Utah. So we should be quite busy this fall, though my fellow AAGs around the country, litigation is what we do. So as we litigate in a variety of jurisdictions, even more now, as last winter Congress agreed that we should stand equal to my federal counterparts here on the stage with us in our choice of venue. We appreciate that both Chair Khan and AAG Cantor wrote letters of support in addition to the 53 attorneys general who successfully persuaded Congress to include the State Antitrust Enforcement Venue Act in the Omnibus Appropriations Bill. The combination of, again, many diverse viewpoints coming together to support something for the common good is what makes the AGs and the NAG Antitrust Task Force such a formidable force. States have already put that law to good use. First, earlier this month, a Virginia federal court noted that Congress had expressed serious, significant concerns about subjecting government enforcers to the delays caused by consolidation with private litigation, and refused to let Google transfer the Justice Department and 8-state Google Ad Tech case to New York to join it to the similar Texas plus 17-state Ad Tech case. In the Texas-led Ad Tech case, just last week, the states filed a motion with the Judicial Panel on Multi-District Litigation to send its case back to Texas, arguing that the Venue Act stripped the New York court of jurisdiction. Another Google case, we have 5, the Google in-app payments case, knows about the potential delays of being joined to private litigation, with trial currently set for, as I just said, November 6th of this year. The state's trial may be delayed because Google is challenging class certification before the Ninth Circuit. Those delays are why Judge Brinkema will likely be quoted endlessly for both her denial of the removal motion and her quip to get for counsel to get their running shoes on. So states, legislatures also have their running shoes on, and as I've said before, they're fulfilling their roles as laboratories of democracy. They've been at the forefront of labor issues. In particular, many state legislatures have addressed the issue of non-competes. Labor has always concerned attorneys general as workers and business owners navigate each other's varying laws. Enforcing non-compete violations has been a signature project of many offices, including New York and Washington State, amongst others. New York's successes last week included a settlement with 2 title insurers, AmTrust and First Nationwide, who allegedly engaged in no-poach violations. They recently settled that case for $1.25 million, and that built on the $1 million settlement that New York had negotiated with Old Republic. And then only 2 days ago, New York, thank you very much, New York, settled with Fidelity National for $3.5 million for that same alleged no-poach conduct. Washington State's leading efforts on no-poach agreements were shown in a study last year to have increased wages 3% nationwide at firms subject to a no-poach order. During the no-poach initiative, Washington's Attorney General prosecuted more than 185 chain franchises for agreeing not to poach from other franchisees. States are not all of one mind on how to handle non-compete issues. Currently, state statutes range from an outright ban on the enforcement of non-competes in California to states like Wisconsin, whose courts consider only the geographic scope and time of a contract when considering the legality of a non-compete clause. The proposed rulemaking by FTC will preempt these varying state laws and move the enforcement regime to the federal government and away from these experienced state enforcers. As a result, I expect that you will see a variety of opinions from attorneys general in our various comments on the FTC's proposed rulemaking. On an issue where I think there's much more unity, states are not automatically notified about merger challenges under HSR. While we have seen huge improvements from merging of parties approaching AG offices earlier, expediting waivers with our federal counterparts, many state legislatures and attorneys general are troubled by notification failures and delays. To address this, and you've heard this throughout the week from probably some of the 17 state panelists we've had during this conference, those state legislatures are trying to make HSR notice more straightforward on healthcare-related transactions, and some states are even considering broad HSR notification statutes. So, until there is a federal rule or law, if you practice merger work, you need to pay attention to what states are affected by your transaction, as the fines in some states for noncompliance are severe and calculated by day. Prompt notice is important for us and for merging parties. And as we've just heard from Chief Executive Cardell, it can be also good for business because it will save your clients time and money when we effectively coordinate. And we do effectively coordinate on both mergers and conduct cases. It's nice to be able to go first because then I can steal some of your thunder. So the Google search case filed here in the DTC, both the US DOJ Texas case, it's the one I'm on, and then the states-only Cone case are, as I've said, headed for trial this fall. But while they're joined for the liability trial, the Cone Google states filed a broader case than the DOJ complaint, and they believe that will reveal the full scope of Google's monopoly maintenance conduct and set the stage for effective remedies that both stop and erase harm to competition. Fortunately, this case has been tremendously fast-moving for a conduct case. However, too often, conduct cases may drag on for years. Lengthy proceedings mean that the relevance of trade secrets and documents under seal diminishes with time. And as it was pointed out on a panel yesterday, not all inconvenient facts are trade secrets. Considering this, a handful of years ago now in the generic drugs case, the state of Connecticut was successful in unsealing the complaint. More recently, we saw the US Department of Justice and states avoid this issue altogether and file the Google ad tech case on the public docket with no redactions. I hope this is a trend that will continue. States as law enforcement officials need to ensure that the public have access to the allegations against wrongdoers, alleged wrongdoers. Another trend I expect to continue is single state antitrust cases filed in state courts. And before I hear from states around the country after this panel, they only gave me 7 minutes, so it's just a sampling. On January 12th of this year, the California Attorney General's office filed a lawsuit in state court against the nation's largest insulin makers, Eli Lilly, Novo Nordisk, and Sanofi, and pharmacy benefit managers, CVS Caremark, Express Scripts, and Optum Rx, for allegedly driving up the cost of insulin. This lawsuit asserts a claim under California's unfair competition law, which is broader than California's Cartwright Act. Both Mississippi and Louisiana also have cases against insulin manufacturers and PBMs, and I'm sure there are others. There are definitely announced investigations from Texas and Michigan, and I'm sure other states as well. Ohio last week filed suit in state court against, well, I think that was actually this week, time flies, filed suit in state court this week against PBMs owned by Cigna, Humana, and Prime Therapeutics, and their affiliated GPO Ascent for rebate practices in violation of Ohio's Valentine Act, which Tom knows quite well. Uniquely, this suit includes the effects of PBM behavior on pharmacist actions. So, with all of these state antitrust enforcement actions underway, I want to close with a nod to a recent article in Antitrust Magazine by John Mayo and Mark Whitener that noted that agency budget levels, and they just studied your agencies, have a positive and statistically significant effect on enforcement intensity. It seems obvious that a larger enforcement staff means that antitrust enforcers bring more cases. And this is certainly true for the state AG's antitrust task force. While our numbers have grown, we have room for more. So if you would like to join us as we continue litigating, commenting, and cementing our unlikely alliance, there are openings in many AG's offices, so please come over to the right side. In beautiful locations across the country, from New England to Hawaii, I'm not kidding, we're interested in having you join us fight the good fight.
Thank you very much, Gwendolyn. I'm going to resist the temptation of asking you about particular cases, not least because some of my colleagues are challenging those cases before the courts. I would like to ask you a follow-up question, though, around labor issues, because sadly I'm seeing that it's not only in the US, it's also in the EU. We also see snippets of labor issues cropping up in Asia as well. What do you put it down to, this focus on labor issues, antitrust and labor? Is there a particular reason that's driving this interest, certainly at the state levels?
Well, I think that almost certainly that, and again, there's a variety of state views on this, but I think that almost certainly because people who are workers are residents of our states, right? So we have a particular interest. I've heard Trish Connors say many times that state AGs are not just antitrust, right? We have a broad array of concerns. And so those concerns include things like, is there a factory in this town and it is going to close, right? So I think that there's a wide variety, but I think that is the real main reason.
That's really helpful. In the interest of time, I'd like to shift to Jonathan. What are you seeing as, in terms of your progress towards the priorities that you've set yourself at the Department of Justice? I got it right this time.
It's a great question, but I'm still stuck on the job opening in Hawaii. Just learn a little more about that.
I bet what Rod would give you consideration.
Okay.
We might need to fight over that.
Let me start just with if you'll indulge me. I did a lot of thinking this morning. Last year, I had the pleasure of being on this panel. Unfortunately, it was remotely because, like many, I was down with COVID, and I was recovering with a very ill-advised COVID beard, I might add, which has been removed. And so this is my first opportunity to be alongside my friends and colleagues in person. And that's quite meaningful for me. It caused me to think back to my very first ABA spring meeting, which, and I'm going to date myself here, was at the Marriott Wardman in Woodley Park. And I remember going to the enforcers panel, and at the time, it was in a room that seemed impossibly large, which is probably a quarter of the size of the room today. And two luminaries, for me, Joel Klein and Bob Potofsky, were on stage talking, and it seemed so far away, and they seem so large in personality and importance. And to be here today, sitting in this very comfortable seat, and it is quite comfortable, it is a very meaningful moment for me personally. There have been some other changes too. For starters, I'm joined by colleagues from around the world and around the country. And I think that speaks volumes about the importance of competition policy and competition enforcement. Additionally, I'm sort of proud to say I think I'm the only male enforcer on the panel. And so I think that's real progress. So as I was talking to you all last year, I was just a few months into my position, and now I'm a little over a year in. And I'm happy to share some observations about where we've gone and where we're going. So for starters, I, again, in a moment of, if you'll indulge me, I love going to work every day. I love my job, and I love the people I work with. The team at the Antitrust Division we often use the word family because it feels that way, and we are family. The people at the Antitrust Division from start to finish work so hard, impossibly hard, on complex matters, and they do it with a deep sense of passion and urgency and dedication to the public. And the issues confronting us today are more complex, more burdensome, and more widespread, perhaps, than any time in 100 years in the antitrust world. And our team shows up from start to finish, all nearly 800 of them, with that passion and that dedication every day. And I'm just moved, sometimes nearly to tears, by how amazing, how talented, and how successful they are. And I want to point out that notwithstanding the gravity of this moment, the importance of the moment that we're confronting, which I think is probably an inflection point in antitrust enforcement on par with 100 years ago, in the trustbuster era. But we're doing it with more than 220 fewer people than the Antitrust Division had in 1979. Stop and think about that for a moment. That given the complexity of our economy, the size of the monopoly problems we're facing, the team at the Antitrust Division has more than 220 fewer people than we had in 1979. That is something else, and something that's worth reflecting on. So let me talk a little bit about the work that we're doing. And I'll start with our civil program. First and foremost, we are enforcing the law. We follow the facts in the law wherever it takes us, and we are bringing cases that are consistent with legal precedent and the facts. On the merger front, there is no success greater for us than deterrence. And deterrence comes in many forms. But when we are ready to file a case and a party abandons a merger, that is success. We have had 6 public abandonments, but I can tell you there are many more non-public abandonments. And that is because of the hard work of our team, uncovering issues and bringing, demonstrating the willingness to bring strong, formidable, and winning cases. We've succeeded in winning the first litigated merger victory at the Antitrust Division since 2017, the Penguin Random House Simon Schuster case. And that case was not just a victory in a standard merger matter. It was a victory in a merger matter first involving a product, in this case, books and authors, that is vital to the public discourse and thus our democracy. But we did it on a theory of monopsony. It is essentially a labor theory that the professional authors who depended on advances to research and write books, often depending on that money for their livelihoods, to support their families, to hire employees, to do the work, to bring the creativity necessary to bring our free speech to the masses, we protected competition, and we did so valiantly. Section 8 of the Clayton Act has been the law since 1914, but never in our country has there been systematic enforcement of Section 8 of the Clayton Act until now. Now we have a vibrant Section 8 enforcement, interlocking directors. We've had nearly 15 directors step off the boards of their companies due to Section 8 enforcement efforts, and we have nearly 20 open investigations. And let me just say, there are many additional opportunities out there for investigation and enforcement. And it is the law, and we are going to enforce it. And in many respects, it is probably the most effective way to deconcentrate the United States economy today. Section 2. Until the Antitrust Division brought its case against Google along with our state AG counterparts in 2020, it had been over 20 years since the last filed standalone Section 2 litigation case, and that was US v. Microsoft. Now we have multiple Section 2 cases in litigation. We have many investigations underway. Section 2 of the Sherman Act is the cornerstone of our antitrust laws, monopolization. And we are going to not hesitate to bring monopolization cases when supported by the facts and the law. We are also recognizing that markets change and so do market realities. And so while many of our case precedents relate to poles and wires, many of our market realities today relate to ones and zeros. That changes the economics. That changes the market realities and the facts on the ground. And we are going to recognize those shifts. And we're going to bring cases again when the facts and the law support it. On the criminal side, we have more open grand jury investigations than any time since 1989. We have brought, for the first time since I was probably this high, a criminal monopolization case. We had a sentencing hearing earlier this week. Criminal monopolization, a monopolization Section 2 in the Sherman Act is both a civil statute and a criminal statute. Congress wrote it that way. Congress made it a felony. And when appropriate, we're going to enforce the law when the facts and the law support it, and consistent with the principles of criminal prosecution. We have another criminal Section 2 case slated for litigation this summer. It is a vibrant, live area of the law. When it comes to labor, we are fighting it both for workers on both the civil and the criminal context. In the civil context, and I mentioned the Penguin Random House case on the merger side, we brought a major information sharing case relating to workers in meatpacking processing plants. These are extremely important efforts. On the criminal side, we are fighting every day to protect workers from illegal behavior. And this is extremely important. And let me pause on this for a moment. We've had now 4 courts. We've litigated successfully 4 motions to dismiss in courts. And those courts have said, as a matter of law, antitrust crimes dedicated to worker or focused on workers are just as important and just as actionable as antitrust crimes focused on consumers. That is extremely important. And when we think about labor antitrust cases, we think about people. This is not an academic exercise. This is an exercise in criminal enforcement. And again, our cases are informed by the facts, they're informed by the law, and they're informed by the principles of federal criminal prosecution. But when companies engage in wage fixing, or companies engage in agreements not to hire each other's employees, that affects the ability of hardworking people to find jobs, to earn a living wage, to support their families, to save for retirement, to put their kids in school and save for college. Those are real harms, and those are righteous cases, and we will continue when the facts and the law support it to bring those cases. We are expanding our toolkit to improve detection of criminal and cartel behavior. We are modernizing the tools that we use to make sure that we are detecting, with or without leniency, antitrust crimes and bringing cases when appropriate. And we're doing so domestically and internationally alongside our international colleagues and enforcers. But we're doing more than just that. On the policy front, we have the wind in our sails with an executive order from President Biden that mandates a whole-of-government approach. And that is exactly what we're doing. In just this past year, we brought the first Antitrust Division Packers and Stockyards Act case perhaps ever. We've worked alongside our colleagues at the Department of Transportation, the Federal Communications Commission, Federal Maritime Commission, and many others to make sure that we are enforcing the law effectively, including with that fly that just but this is extremely important, this whole of government approach. And we've signed MOUs with a number of key agency partners, including the Department of Labor and the NLRB, and an extremely important historic MOU with our colleagues, Inspector General at the HHS, that addresses exclusion orders when there are antitrust crimes committed by healthcare companies. This is extremely important. We are filing more statements of interest and amicus briefs that help make sure that courts are aware of the Department of Justice position regarding the law. This is just the tip of the iceberg, and this is the work that we are doing. I will also add, and to wrap on this, is we're doing it by expanding our expertise. So we agree in labor competition, and so we are hiring as well. I can't compete with Hawaii, but we can say that we are hiring, and the resumes, the talent of the folks at the Antitrust Division is off the charts, and so you can join one of the finest antitrust enforcement teams ever assembled in the history of the world, in my view. But we're also hiring experts. We have over 50 PhD economists in our expert analysis group, and they're brilliant, and they work extremely hard. But we are also recognizing that as market realities change, so does our need to make sure that the need for our expertise. And so we're expanding our expertise to include what we like to think of as a business school faculty that includes world-class economists, the best in the world, alongside data scientists, alongside business strategy analysts, banking experts, healthcare experts, because we need that expertise to make sure that we can see facts. We need that expertise to make sure we can understand the economics of the industries that we investigate and to bring our cases effectively. And so I'm extremely excited about the work we are doing that front under the leadership of our chief economist, Susan Athey. So with that, like I said, that was year one, and I'm ready for year two.
Thank you very much, Jonathan. You made a very interesting point, both on the criminal side and the civil side, that you only really take action when the facts and the law support it. For some, if I may say, some may argue that the enforcement we're seeing is almost a step back, a slight step back, but a step back nonetheless, away from the Chicago School. Or perhaps it's also could be perceived as a departure from what was erstwhile a specific or narrow interpretation of the consumer welfare standard. So my two to you, is there a risk at all of over-enforcement? Obviously, you've been very active, and that's to be welcomed. But again, is there a risk of over-enforcement?
So I think there is our job as a law enforcers is to enforce the law, and when we see violations, and we believe that they're supported by the facts and the law. There's a lot of doctrinal discussion, and that's healthy and fun, and I think, I'm sure reverberating through the halls of this great conference. But you talk about the Chicago School, that was a radical departure from over 100 years of antitrust enforcement when it came into being. And so, I think we need to be faithful to the intent of Congress. We need to be faithful to the text of the statute. And we need to be faithful to a mandate from our legislators that competition matters. Why? Because they said so. Our Congress determined, in its wisdom, that a competitive economy in a democracy go hand in hand. And so we enforce the law as it's written by Congress. We enforce the law as it's interpreted by courts. And then we follow the facts and the law. And if we see violations and we see harm to competition, we take action. I think that is entirely appropriate.
That's quite a strong statement there. which we'll come to later on. But perhaps if I can turn to you, Lena, in terms of the priorities that you've set for the FTC and your progress towards achieving those priorities.
Thanks. It's terrific to be here and really fantastic honor to share the stage with my fellow enforcers. So we at the FTC recognize that there are major competition problems across the U.S. economy, and we are working with tremendous urgency to use all of our tools to make sure that we're protecting the American public from illegal business practices. There are a few key pillars of this work. First of all, we're taking care to ensure that we are fully enforcing the laws that Congress has charged us with administering. And this means taking a close look at the FTC Act. It means taking a close look at the Clayton Act, again, to make sure that we are being faithful to Congress's instructions and fully enforcing the law. So there have been a few key parts of this already. First is Section 5 of the FTC Act. Congress created the FTC to be a complement to the Antitrust Division, not a substitute for it. And Section 5 of the FTC Act is really at the heart of the FTC's reason for being. Section 5 prohibits unfair methods of competition. And we take those words very seriously. One of my first priorities once I joined the agency was to make sure that we were taking care to fully enforce Section 5. Last fall, we were really pleased to be able to publish a policy statement that lays out our interpretation of Section 5. The policy statement is 16 pages. It has 89 footnotes. This document reflects a very deep study of 60-plus years of jurisprudence and doctrine that lays out how the courts have applied standalone Section 5. We had a terrific cross-agency team that really went through the case law, hundreds of cases across multiple decades, and laid out what have courts said about what Section 5 means. The policy statement that we laid out reflects this research, and it's pretty straightforward. Unfair methods of competition means you have to be able to identify a method of competition that is unfair. The unfairness prong looks at a few dimensions, including whether the practice might be coercive, exploitative, predatory, as well as whether it may have certain exclusionary impacts. We also look at whether there was a negative effect on competitive conditions. And so the policy statement is a key pillar of our work. I'm really thrilled that we've been able to already move forward with enforcement on standalone Section 5, including some of our non-compete work. So several of the enforcement actions that we've brought have been addressing illegal uses of non-competes. There are at least 2 instances that we've identified in which non-competes have been illegal in our enforcement. First is in the context of usage by Prudential Security. This was a security guard company that was applying non-competes with security guards who made pretty much a little above minimum wage. The non-compete restricted them for 100 miles and 2 years after they left. And the FTC determined that this was an unfair method of competition, required that these non-competes be voided and that the company actually affirmatively tell the employees that these non-competes were no longer in effect. We also brought an enforcement action addressing non-competes in the glass manufacturing industry. So this is an industry that is tremendously concentrated. You have 3 big players, and the FTC found that all 3 of the players had been using non-competes. Unlike the security guard instance, where our complaint noted that the use of the non-compete had been coercive, in the glass industry context, it was really the aggregate effect on competition that our law enforcement was intended to address. Because we understood that you may have entrants that want to disrupt this concentrated industry, but if these entrants, even if they're able to secure financing, build factories, they'll see that a lot of the talent, and this is highly skilled technical talent, is locked up by non-competes, and that this was having an aggregate negative effect on competition market-wide. So we were thrilled that we were able to bring these 4 enforcement actions, laying out one application of Section 5. We've also been reactivating Section 6G of the FTC Act, which gives us the authority to promulgate rules under Section 5. In January, we came out with our non-compete rule, which would prohibit non-competes across the economy. And there are a few reasons we did this. Our economists undertook significant empirical research to understand what are the net effects of non-compete clauses across the economy. As I'm sure many of you know, non-competes over the last few years have no longer just been restricted to the boardroom applied to highly paid executives, but have now proliferated across our economy in situations covering fast food workers, gardeners, journalists. And so the use of them has dramatically expanded across our economy, and the empirical literature shows that this is having a significantly negative effect on competition. It is impeding business dynamism, it's impeding new business formation, and our economists calculated that eliminating non-competes would result in $300 billion back in the pocket of workers. We've also seen the way that non-competes applied in some of the highly skilled workers, including some executives, is in fact impeding innovation and business dynamism as the proposed rule lays out, because it's oftentimes these workers that are best positioned to actually spin off and start their own new business. So we determined that there were economy-wide effects, and it was really for the FTC to be addressing these through our rule. Interestingly, there are a whole set of states that have already effectively prohibited the use of non-competes, including California and North Dakota. And interestingly, we saw, well, first of all, there hasn't, I think it would be difficult to argue that there has been a detrimental effect on innovation in California. But we've also seen how even in states where non-competes are banned, non-competes are still included in contracts at roughly the same rate as they are in states where they aren't. And so there really is the role for a national federal rule here that would really ensure that we're leveling the playing field and making sure that workers are free to take their talent where they wish, and that this is going to have in the aggregate really beneficial effects on competition economy-wide. In addition to Section 5, we've also been looking closely at the Clayton Act. One of the lawsuits that we brought last year was against Syngenta and Corteva, two massive pesticide manufacturers. And the FTC's lawsuit alleged that these companies had been engaging in illegal pay-to-block schemes, where they were basically engaging in conduct that had blocked out generics from the market. We were really thrilled to sign on with 10 state AGs on this lawsuit. And one of the counts in the complaint included Section 3 of the Clayton Act. The Clayton Act is distinct from the Sherman Act. In some instances, they cover similar or the same conduct. But the legislative history shows, and the Supreme Court's precedent has supported, that the Clayton Act was really designed to stop illegal behavior in its incipiency. Lawmakers recognize that unlawful conduct and unlawful anti-competitive conduct can be extremely difficult to reverse, right? Oftentimes you're talking about many years or decades in some instances during which entire alternative futures have been foreclosed, right? This is competition that was squashed, this is innovation that was foregone, and it can be extremely difficult for us as enforcers, even if we're able to ultimately stop that conduct, to actually be able to provide relief or remedy that ever brings that innovation back. And for that reason, Congress was adamant that we have to have tools that enable us to stop illegal behavior in its incipiency. Consequently, the standards in Section 5 are distinct from the standards in Section 1, and so, under the standards in the Sherman Act, and so we think it's incredibly important for us as enforcers to be honoring that distinction. And so we were, in our pesticides complaint, it made sure to be including a count under Section 3 of the Clayton Act, and that's an area where we're looking to continue building out. We've also been using our policy tools. So the FTC was created not just as a law enforcer, but also as a policy body. We were given market study authorities. We've been using 6B of the FTC Act to really deepen our understanding of business practices and particular markets. Two particular studies that we've launched over the last year, including one study looking at supply chain disruptions. So as we're all very familiar, in the wake of the COVID pandemic, there were major supply chain disruptions. A whole set of factors contributed to that, but we were hearing from market participants that there may have been underlying market structures or potential business practices that was really exacerbating the effects of those supply chain disruptions and having a disparate impact potentially on rural areas and certain communities. So we launched a 6B for where we basically sent out information orders to significant wholesalers and retailers and distributors to understand what are some of the underlying competition dynamics that may have contributed to worse supply disruptions, and what are particular business practices that need to be on our radar. We also launched a 6B looking at the business practices of pharmacy benefit managers. So pharmacy benefit managers are major middlemen in the pharmaceutical supply chain, and we've heard significant feedback from patients as well as from independent pharmacists about some of the business practices of these PBMs and how these business practices may be hiking prices for consumers and patients beyond what a competitive market should be providing, as well as potentially squeezing independent pharmacies through a whole set of business practices that are really creating a detrimental impact on local communities. And so we've been moving forward with that 6B, and we think it's an incredibly important part of our work. In addition to fully activating the Clayton Act, the Section 5 of the FTC Act, we've also been continuing to vigorously enforce the merger laws. Just over the last few months, the Commission filed to block Microsoft's attempted acquisition of Activision, as well as ICE's attempted acquisition of Black Knight. Both of these cases have vertical dimensions, which builds on the phenomenal work the FTC staff has been doing to really aggressively block not just illegal transactions that have horizontal components, but also make sure we're putting the market on notice about how we view vertical harm. So this follows on our work earlier in NVIDIA ARM, Lockheed Aerojet. This will remain an important part of our work. In addition to fully reactivating these authorities, we're also making sure that our tools and frameworks are fit for purpose. So markets evolve, business realities evolve, and we need to make sure that as enforcers, we're fully adept to the business strategies of today. So there are a few projects that we have underway here. One is our joint effort with the DOJ to be revising our merger guidelines. A key pillar of this effort is to make sure that the guidelines are fully reflecting commercial realities, fully responsive to the types of business incentives and business strategies that companies today face, including in digital markets. And we're excited about some of the internal progress we've made, and we're excited in short order to be able to share a draft publicly. We've also been making sure that we're fully skilled up. And we have a fantastic set of lawyers, a fantastic set of economists, but many of the markets that we're investigating these days have a digital component. This is not just limited to what are considered tech markets, but as we see digitization across the economy, many of our healthcare cases, for example, may include a digital component. Many of our agriculture cases or retail cases. So as we see more and more digitization, we need to make sure that we as enforcers have the skills and tools to fully understand how are these technologies working. Since I've joined, we've managed to double the number of technologists that we've had on board, and we've been piloting, for the first year that I was on board, piloting a program where technologists were embedding across the agency, embedding across investigations, and working hand in hand with our lawyers and economists to craft CIDs, to be contemplating what effective relief would look like. Just last month, we were able to officially launch a new Office of Technology, which I'm tremendously excited about. And there's an enormous interest in joining we've seen. Just in a few days of having the posting up, we got 300 applications from technologists, and so we're well underway to bringing more folks on board. We also have been using our market study authorities to making sure we're understanding how some of these newer markets are functioning. Just a few weeks ago, we launched a RFI that's looking at cloud computing, looking at both competition issues in cloud computing as well as some of the data security issues. It's no secret that cloud computing is primarily dominated by a relatively small number of companies, and we want to make sure that we're fully understanding what's contributing to that, whether that fact is contributing to business practices that might be exacerbating potential competition implications, and also what the potential resiliency effects are here. We've all seen how when you're concentrating production, you can also be concentrating risk, such that a single point of disruption can have cascading effects and really lead the entire system to seize up. And as we have more and more economic activity reliant on cloud computing, we need to make sure that we're being very vigilant about what some of the systemic implications of that could be. So this cloud computing RFI is going to be critical for building out deeper understanding there. We're also vigorously enforcing the law, including in nascent markets. Last year, the FTC filed a lawsuit seeking to block Meta's acquisition of Within. Unfortunately, earlier this year, we did not win the PI, but the opinion really set out a roadmap for the FTC to be continuing to build its work in this area. The judge reaffirmed that potential competition is alive and well, and the potential competition can apply in newer nascent markets. The opinion is really rife with explanations from the judge that really went the FTC's way including on market definition, including on affirming that it's entirely appropriate for the FTC to be using the practical indicia under Brown-Shoe to be defining a relevant market, that we don't always have to be using qualitative as well as quantitative methods, and that in many instances qualitative may be best suited to actually explain what the state of competition really is. The judge also adopted a reasonable probability standard for what governs under potential competition, which is a lower standard than what some other circuits have adopted. And so we saw this case as an important programmatic win that really lays out a path forward for us to be continuing to vigorously enforce, not just in standard industrial age markets, but also in digital markets, which provides so much opportunity for disruption and innovation, and we think it's critical that we as enforcers are safeguarding that potential for innovation.
Thank you very much. Just wanted to pick up on your point about market studies. You said the focus has been very much in digital markets, and other studies you've done are well rehearsed in the media and so forth. Are there particular other sectors that are of interest that you can foresee are becoming priorities for market studies? And in answering the question, perhaps you could also explain the underlying factors, the structures that you mentioned are informing whether or not you decide to launch a particular market study in a particular sector.
Yeah, it's a great question. And I view our policy function and our markets studies function as a complement to our enforcement function. So these really go hand in hand, and historically have for the FTC, right? If you go back and look at some of the major market studies that the FTC did, it included a major study of the meat packers back in 1920. It included a major study of the public utility companies back in the 30s. And both of these studies ultimately led to either major enforcement actions or actually legislative action. In the case of the public utilities, the FTC study led to the Public Utility Company Holding Act, which effectively broke up and restructured the entire industry. So we recognize that these studies can play an incredibly important role in informing us as enforcers, but also with informing more broadly the public and policymakers who, if we don't have the tools to address a problem, may be better suited to do so. So, there are a few factors that go into how we decide whether to pursue a market study, one of which is, what are we hearing from the public? One of the things that I'm most proud of doing at the FTC since I've been there is starting open commission meetings. So these are commission meetings where we are going through various agenda items that the commission is voting on, but we also have a portion of the commission meeting where anybody from the public can sign up and come speak to us. Every time we have people sign up and come talk to us about a full variety of issues, be it hearing from franchisees about problems that they're facing with their franchisor, hearing from families about how their kids have had to ration insulin. We've heard from people about problems that they're facing in the retail markets, independent grocers, independent pharmacists. We've heard from farmers about problems that they're facing with right to repair, where they haven't been able to repair their equipment. And in farming, where time is of the essence, this has led to massive economic devastation in some cases. So it's really partly what we're hearing from the public about where the problems are in the economy that we're taking back and identifying, do we have enough of an understanding about what's going on here? The other thing we look at is what is the potential impact? It's no secret that there are many ways in which the current healthcare system is not working well for patients. And so we're looking closely at what are the different components of that in our wheelhouse that we can be making sure to be moving forward. Because in healthcare more than anywhere else, the effects of a lack of competition can really be life or death in some instances. And so we take that very seriously.
That's helpful. Thank you very much. Margherita, last but not least, I'd be interested to hear your thoughts around the priorities that you've set, and perhaps a critical assessment from your perspective as to your progress towards achieving those objectives that you set.
Well, first and foremost, I never thought I should say this, but oh my God, I'm glad to be back in a room without windows and hundreds of lawyers. I'm very, very proud to be part of this law enforcing community because competition has never been more important. In these times where we discuss resilience and the geopolitics, to have competitive, contestable markets where you can find a new supplier if you lose the one you have, you can find a new customer if you lose the one you have, and you have the drive from competition to innovate, absolutely crucial. So I'm just very honored and proud listening to colleagues about all the work being done to secure that citizens in their role as consumers have the benefit of competitive markets. We've been busy as well. If we look at our merger work, I think since we saw each other the last time, we've had 16 intervention merger cases, 10 conditional clearances in phase 1, 2 conditional clearances in phase 2, 2 prohibitions, and 4 deals that were abandoned. So I think effectively 6 prohibitions. And I think the one that has attracted the most attention is the Illumina Grail case, both for the question of jurisdiction, because here the Illumina Grail case doesn't meet our thresholds. It's not notifiable in any member state. So it was on the basis of Article 22 that we assessed this case. The question of jurisdiction was appealed, and we were, of course, very happy that the General Court sided with us to say, well, yes, you do have jurisdiction, both in general but also in this case. Now that, of course, is under appeal for the ECJ, but also on substance, I think it's an interesting case, because it's the first sort of purely vertical case that we have blocked. On the basis of an innovation theory of harm. Because Illumina is the only credible supplier if you want to develop and test cancer detection tests, which is what Grail is doing. And if Illumina is the only one to do that effectively when, of course, there's a really high risk that the competitors to Grail would not be able to have access to develop and to test their early cancer detection tests. So what we did was, of course, that we saw that here there was a risk of a loss of competition in innovation. And on those reasons, we blocked the deal. That is now, of course, also in front of the courts, and we are preparing the gun jumping case as well. So it is a multifaceted animal that we're dealing with here. This will probably not be the last case that we will assess, even though it doesn't meet the threshold, non-notifiable in a member state, because with the implementation of the Digital Markets Act, we will have much more information about acquisitions of a larger company buying a smaller company. Because companies designated as gatekeepers, they will have to tell us, we are now acquiring this smaller company. And we will assess this to see if there is, of course, a loss of competition if that acquisition goes through. Second thing that has given us direction this year is the judgment in the Google Android case. We were happy with the judgments of the General Court, because I think it's a very important signal when it comes to tying practices. Google tried to protect its monopoly in search when we all went mobile by tying practices, pre-installation, anti-fragmentation clauses to make sure that there was basically no space for anyone else. So this we find to be very helpful in the direction that we're heading. Thirdly, we have finalized our Amazon case with a settlement. And this is a case where there is 2 sides to it. The Amazon Marketplace, Amazon Retail having access to highly rich non-public data from all the many retailers. And that, of course, gives Amazon Retail huge competitive advantage. You also see that since Amazon Retail holds a majority of the products, but takes the lion's shares of the turnover. So here we agreed with a data silo, so that the data of the small retailers will not anymore be available for Amazon Retail. And the second thing was we took a commitment when it comes to access to Prime, so that Prime customers, they are returning customers, they're high-spending customers, they're really important to get access to. And here, of course, the question of whether or not to use Amazon Fulfillment to give more space in order for these retailers to choose themselves who should deliver their goods to their customers. And last but not least, the second buy box that will appear, so that you have two different sort of promoted products to choose from. And we pushed forward with this case. Some will say, oh, but listen, part of this will be solved once the DMA starts to affect this market. But the thing is that we could change this market behavior now. And as someone just told me, listen, 1 year in a digital market is like 4 years in the normal business cycle. So every month that we gain in order to make sure that the market is contestable, that you have your own data, that you can make your business, that month will serve the consumer very, very well. And this is also reflected in the new SO that we sent in the Apple App Store case, where we focus on anti-steering and the direct consumer impact in that case. It's a high priority case for us. Now we're awaiting the Apple response to it. And of course, we have the Meta or Facebook case, where Facebook in its social media ties it with marketplace and combines it with unfair trading practices, which again is closing the market. And that will lead me to just a few words about our policy priorities. The main one, of course, implementing the Digital Markets Act. Of course, the Digital Markets Act is not a competition tool. It's a tool that will make the market open and contestable again. And this is very important for us. It was not easy to pass new legislation in Parliament and Council. But what you change by changing legislation is that you change perception. What you change when you start implementing and enforcing is that you change behavior. Picking up also what Nina just said about looking at legislation, how it's being used, that it's still fresh, that it's still out there, that it's still useful in order to change behavior. And that, of course, is our focus. We have very tight deadlines. First to get the notification from potential gatekeepers, then to designate them in order to have compliance early spring next year. And that is absolutely high priority because we need that change of behavior in the marketplace in order to get the benefits from competition to serve the consumer. We have another new tool, which is the foreign subsidies regulation that comes in. Again, we want to protect those who do business in the single market without subsidies in their books from foreign subsidies. In particular, we think from non-market economies. So we are building up on that as well. And then we have made a call for evidence in our guidelines on 102 cases. It will take some time to get there, so we have also made a communication to change our guidance paper from 2008 in order to reflect what has been the case practices. And all of this, just to say that we keep ourselves busy, but we do that whilst at the same time making our international cooperation a priority. We have different laws, we have different markets, we have different legal barriers to pass, but we're on the same mission to make sure that we serve the citizen well in their role as consumers. So it is really important for us that we work well, that the teams have time and priority to speak with one another, to share insights. Very happy that we just had the technology competition policy dialogue here just yesterday, because When we need the markets to serve us, you also need enforcers to work together, and this is why it's such a pleasure to be here.
Thank you very much, Margrethe. At a recent conference, I think you said that there are 3 challenges facing the world at large, essentially. I'm paraphrasing. The geopolitical, the digital, and the ESG, and perhaps we'll touch on ESG later on. But it seems to me that the DMA that you mentioned perhaps fits under the box of obviously digital. Maybe the foreign subsidies tool you mentioned also fits under the geopolitical tool. And you also mentioned you'd be very busy. I guess a question from my perspective is there sufficient resources? Is the Commission fully prepared to be undertaking these quite radical changes and shifts in approach and in policy?
Well, I only see them as radical in sort of the original meaning of the word, which is sort of going to the root causes of these problems. And if you take the Digital Markets Act, the root causes of the problems we have is that the market is not contestable anymore. It's not open. I think what also Gwendolyn and Sarah took us through numerous cases, case after case after case after case. You know, I admire what you say because it's part of my sort of speaking line. I say I have not 1, I have not 2, I've had 3 Google cases. And then we have the same as the one Jonathan has filed with the states. And what you have doing here, I think is also pushing the right way. So I don't think that it's radical. I think it's completely in line with the mission that we have. We will never have enough resources. Never, ever. And listen, you are literally on the dark side today. We can hardly see you. So the more who wants to join, of course, the better. But no matter the resources that we have an obligation to use them in the best possible way. And I think what also was said previously, that we need to complement sort of different approaches. We are also now establishing sort of the office of the Chief Technology Officer to have more of those competences on board. When we enforce the Digital Markets Act, we can make common investigative teams with the national competition authorities who are also, you know, powering up with other competences. And I think that is the trick, of course, for us to be as efficient as possible with the resources that we have. And the last thing, of course, is that, you know, they say it takes a village to raise a child. It takes a community to secure compliance. So we are talking with everyone and his sister to make sure that they will watch out for compliance with the Digital Markets Act. Data Protection Agency, Consumer Protection Agency, NGOs, business associations, unions, in order to make sure that we can use our enforcer resources in the best possible way.
My takeaway right now is going to be that I think for the first time, someone said I'm sitting on the side of light as opposed to the side of darkness. So I feel good about that. Let me pick up, if I can, a word you used, Jonathan, and a concept you mentioned, Lena, and it's going to sound very U.S. federal-centric, but I'd like to get everyone's view. You talked early on about deterrence, right? And one of the examples was abandoned transactions, as well as the actual enforcement actions. And that, in a sense, if I can oversimplify, at the retail level, right? There are an action, a reaction. Lena, you mentioned guidelines or guidance. I'll take that broader. And so I can start with you, but if others want to weigh in, among the toolbox that we look at in terms of advising businesses and helping them understand what they ought to be doing are guidelines and guidance. Your testimonial and endorsement guidelines are always at fingertip because that's helpful. The green guides, quite helpful as businesses have questions. Thought comparatively, if I can get your view, and then maybe of others as well, is the value of publishing guidelines and guidance to businesses so they can proactively say, here's how we're going to operate ourselves, here's how we are going to make judgments about what we do and know where the lines are to keep our toes on the right side. Have you found those efficacious? Have you found those something in your toolbox where it's useful to maintain those and potentially increase their use?
So the Federal Trade Commission has a long history of publishing guidelines and guidance on the competition side, but especially on the consumer protection side. And one initiative we have underway on a whole host of areas is to be revisiting some of those guidelines and updating the guidance where it needs to be, including the Green Guide specifically. In addition to the guidance documents, the FTC has also been making use of policy statements. So the Commission, since I joined, has voted out several policy statements that articulate how a particular set of laws may apply in a particular context. In some instances, they may highlight a particular legal provision that perhaps previously had been underappreciated. One example of the latter is we published a policy statement noting that the Children's Online Privacy Protection Act actually prohibits firms from conditioning access to certain services on endless collection of data. So oftentimes COPPA is thought of as kind of a notice and consent regime where you just check the box, but there are actually, upon closer inspection, substantive limitations on when firms can be collecting data. So that was one thing that we thought the market should be on notice. One thing that we're doing across our digital privacy work is making sure that we're fully enforcing the law, including in areas where there are substantive protections, because I think we've all lived the reality of how in many cases you're just forced to kind of check the box and not really be expressing consent in the way that we really think that what that word should be meaning. So we've been taking a closer look, in particular on the privacy side. We also issued a policy statement looking at some of the rebate practices that we've been hearing about between PBMs and drug manufacturers. As I mentioned, this is an area where we've received a lot of public input, both at our open commission meetings as well as some of the public dockets that we've opened. And we set out in the policy statement a few ways that some of our existing legal authorities might apply to some of these practices. One provision that we highlighted included Section 2C of the Robinson-Patman Act, which prohibits commercial bribery and illegal kickbacks. And so that's the policy statement tool has been one that we've also been activating to make sure that where needed, we're putting the market on notice about how the law applies in particular contexts, or gives them renewed appreciation for certain legal provisions that may not have been recently enforced.
Anyone else? The other jurisdictional, maybe less obvious, but in those, the use of guidance to business, guidance to industry, in addition to individual enforcement actions.
Well, maybe not in individual enforcement actions, but we've had a very long discussion about sustainability and competition law enforcement. And here, I think it's important that we give guidance that on the one hand side, we would like businesses to come to us if they have something that they think, would this work? Can we do something? And here I think it's important to give the guidance that we want to see a corporation that can enable sustainability, but we don't want the in-market consumers to be left completely without the benefits of that. And I think the discussion that we have had among competition law enforcers in Europe has been very helpful, first and foremost for ourselves to clear the head, but hopefully also to the business community to say, well, there are things that we can do working together where they will not see collusion left, right, and center. And we are in a situation where it is really, really important that everyone who has, just the slightest contribution to fight climate change, that they get on board for that mission.
Very similar in the UK, both to the US and the EU positions. I mean, we use guidance quite extensively, I think, for two reasons. One is to encourage the good behaviours that we want to see, and also to provide clarity about the way that we will work. Very similar to the EU, we've recently issued draft guidance on sustainability, again for exactly the same reasons. And we've gone a little bit further than in our usual practice in, exactly as Margrethe said, having a really open door here, because we hear a lot of claims from businesses that competition law has a chilling effect on sustainability initiatives. So we really want businesses to come to us and talk to us, give us those examples, and we will talk that through. And I think, there's also a reality. I mean, a number of us have talked about being resource constrained. We need to use guidance, we need to use advocacy as a complement to effective enforcement so that we can really focus in then on the areas where we need to take direct enforcement action. And we see that quite a lot, similar to the FTC. We see that both on the competition and on the consumer side. To give an example, on the consumer side, we put out a lot of guidance, actually, again, in the environmental space on misleading green claims and what you should expect good business practice to be when giving sort of green credentials on your products and services. But we then very much followed that up with a very clear program of enforcement action where that guidance wasn't being followed to take action against specific companies. And I think that works in a very complementary way.
Sarah, if I may, I'd like to pick you up on the question of the sustainability guidelines that you recently adopted, well, not adopted, but published for public comment. And I think one of the points that the consultation paper makes, says is that this is to ensure that businesses are not unnecessarily or mistakenly deterred from lawfully cooperating or collaborating to promote sustainability. The European Commission has also published some draft guidelines for public comment. Japan has also done the same. There is talk of other jurisdictions doing the same. But I think amongst all the guidelines published, there is a sense that it is really the Dutch Competition Authority that is sort of out there when it comes to assessing consumer benefits, when it comes to assessing whether there should be or there shouldn't be full compensation. We also talked briefly about international cooperation. To what extent is there a possibility to see greater convergence in terms of how one assesses consumer benefits? Granted, this is perhaps more a debate in Europe. I'd be interested in the views from the US as well. But how can we ensure that businesses that you're trying to give them a sense of direction can be assured that whatever works for the UK might also work in other parts of the EU, certainly post-Brexit?
Yeah, I mean, maybe just a few thoughts from me, and I'm sure others will have comments. I mean, I think there's quite a good parallel here when you look at the approach on environmental sustainability and when you look at the approach on digital markets. In both cases, the fundamental underlying issue that we are seeking to tackle is one that is of huge societal importance. One is about climate change and achieving net zero. The other is about ensuring that digital markets work in a positive way for society and are not dominated by companies that can distort the way that competition is working effectively. So I think there is an absolute commonality of objective and recognition of the underlying concerns. And then there is a process of working through jurisdiction by jurisdiction, what is the best way to devise a toolkit and utilize a toolkit to address those issues. And in some cases there will be entire alignment, and in other cases there will be a degree of difference of approach, a degree of experimentation and learning. And I think I have no problem at all with saying, as an agency, we want to learn from other experiences across jurisdictions. I think it's absolutely essential that we work in that way. So when I look at the approach that we've taken in relation to our guidance on environmental sustainability, we looked very closely actually at what the Dutch had done. We looked obviously at the ongoing process for the EU. And we thought very carefully about where we should strike the right balance in terms of looking in particular to this issue, which I think is more of a European one in terms of the analytical framework, but looking at how you trade off the potential harms from a restriction of competition against the wider benefits that may be derived in that case in terms of improving environmental sustainability. The approach that we decided to take in the UK was specifically in relation to climate change agreements because of the enormity of that challenge that faces, because of the quite specific legislative commitments that the UK government has entered into. We felt, and because of the clear case on externalities, we felt that it was important to look at that broader benefit that could be derived from agreements that are legitimately entered into to seek to achieve net zero obligations. But I don't think that there's a sort of fundamental difference of approach there. We will learn from the cases that we take. We will share. So one of the things that we said in the guidance is we want to be able to publish the case studies where we have people coming in so that we can share that learning not only for ourselves but for the wider community.
I think at a Senate hearing, Lena, last year, you made very clear, and I think most would agree with that there are no exemptions, there are no carve-outs or special rules, as it were, for sustainability agreements. Do you anticipate that the FTC might, at some point, then, publish guidelines, or what sort of guidance, in the absence of guidelines, would you give companies in the US or elsewhere seeking to promote sustainability through sustainability agreements? And I'd love to hear your thoughts as well, Jonathan, afterwards.
So look, at the FTC, we really look squarely at our mandate, which Congress has said is to prohibit unfair methods of competition and unfair deceptive acts or practices. So we really look through all of these practices through that prism. I should also say we recognize that the FTC's tools are not going to be appropriate to solve all sorts of problems that other policymakers may want to fix. And so we're very mindful of everything that our tools can do, but also critically their limits. To that end, one thing that we've shared publicly is instances in which firms come to us and say, hey, we're seeking to propose this merger. We understand it may raise traditional competition concerns and may be unlawful under the competition laws, but it has these certain sustainability benefits. It has, it's going to permit us to engage in all sorts of ESG commitments. Those are instances where we've had to establish very clearly that we look at these deals through a competition prism, and any types of ESG commitments or other types of sustainability commitments are really not key to our inquiry. And so we thought it was important to put the market on notice about that. Of course, if some of our traditional tools around unfairness or deception apply, we'll be using those. So if firms are making untruthful claims about sustainability of their products, if they're overhyping sustainability, that's work that we do. We have been focused on some of our Made in USA enforcement that I think also sets a nice baseline for what some of that work could look like.
I just want to add, states have such varying views on this issue. I can't not say something. And first of all, as a law enforcer, I'm always skeptical of folks who need to collude in order to do something good. I mean, I wouldn't come to me with that one, certainly. On ESG, the AGs have really had very divergent views. There is a group, and I will try to articulate both sides to the best of my ability, but there is a group that think essentially that consideration of ESG factors does a disservice to those, especially those state pensions. If you think about if you're investing in oil and the price of gas goes up, then theoretically there's going to be better return for those folks who are invested in those non-ESG funds. Some states have taken on, for example, BlackRock and others with their concerns about that. Conversely, a different group of AGs have said that ESG has the potential to get us to the next stage. It's important to have those considerations, and they argue that if you don't consider ESG, then you will do a disservice to shareholders, because if you look recently when the banks collapsed, those ESG funds, well, they did better than the average funds. So the great thing about being me is those are both the sides. I don't have to take a position.
Jonathan, did you want to comment? Or?
It's a fascinating discussion.
Thank you.
Switching a bit in the time we have, we could get a couple of topics. In addition to choosing which cases to set guidance, the ability to obtain remedies is critical to all the work that you do. And the challenges obviously are vastly different given the structures under which you're working. So this will be more of a question, I know, in light of what the Supreme Court has done with a long-beloved statute, Section 13B. In a wish list sense, in looking out and scoping how to achieve in meaningful ways the goals you've laid out, what would you like to see in terms of remedial powers, remedial abilities that would help make real the enforcement actions and the policies you have? What would you advise and ask for to augment whatever remedial powers you may have currently?
Yeah, I'll start. I guess I have a very pragmatic approach here, which is I truly believe it's the job of our Congress to write the laws, and it's our job at the Antitrust Division and the Department of Justice to enforce them. And so I really think about what are the tools that Congress has provided and how can we use them to greatest effect possible, consistent with the laws as set forth by Congress. And so when it comes to antitrust, there are a wide range of remedies depending on the type of violation. Obviously, in the most extreme sense, in a criminal antitrust case, prison time is a suitable remedy in some instances, in many instances, as well as fines. In a civil monopolization case, it can be everything from a behavioral remedy to address anti-competitive conduct to structural remedies and breakup. And then obviously in the merger context, it's complex, but restoration of competition and making sure that the issues concerning an illegal merger are adequately addressed, and that one area we've become more attuned to in recent years is that some trends in merger remedies have resulted in perhaps goalposts moving out and risk of failure being borne on the shoulders of the American public. And so let me say, for example, if you have a merger remedy and a year after the firm goes out of business, goes bankrupt, decides to change business strategy, in many instances you're left with a monopoly and there's nothing you can do about it. And so we have to be very careful to make sure that when we are enforcing an incipiency statute, that we are enforcing it appropriately. And so we just want to make sure that if there are remedies, they're adequate. That's our concern, that's our mission. But in terms of what, if we provide technical assistance to Congress, sometimes we will weigh in on legislation with an official letter. But more often than not, our mission and my focus is to keep our head down, review the laws that Congress has written for us, and figure out how we're going to enforce them.
Lena?
So at the Federal Trade Commission, we've suffered a setback in the AMG decision, which had been our main tool of getting restitution or monetary equitable relief in antitrust cases. And so, the Commission has told Congress that this is a tool we need back. Basically, overnight after AMG came down, billions of dollars on the table that would have been back in the pockets of consumers, including in pharma cases, evaporated. So this is a really important tool that has now been defanged. We have been thinking hard about what does it mean to fully be able to effectuate a remedy when you have illegal anti-competitive conduct, right? The goals of a remedy are to prevent the illegal conduct, to cure the underlying harm that resulted from the illegal conduct, and to prevent a recurrence. And so we look at remedies through that prism. In the merger context, we've also been taking a very close look, making sure that we're learning from the experience of the last decade, instances where particular remedies failed and the effects of those were borne by the American public, and making sure that we are placing a high bar to make sure that if we are going to be accepting a remedy, that it's fully achieving the underlying goals and restoring the competition that would have occurred absent the acquisition. So that's really what we're doing in the merger context. In the consumer protection context, where the FTC had also heavily relied on 13B of the FTC Act, we've been reactivating other provisions of the Federal Trade Commission Act. So this includes Section 19 of the FTC Act, which enables us to go to court and, after we have pursued a cease and desist order, to actually go to court and get back money for consumers. So we've been able to do that in several instances. We've also activated our Notice of Penalty Offense Authority. So Section 51MB of the FTC Act basically establishes that in ordinary course, there's no civil penalties that apply to first-time offenders. That said, if the FTC has condemned a particular business practice through a cease and desist order, it can then put companies on notice. And if companies then knowingly engage in a business practice that they know that the FTC has condemned, civil penalties can actually be activated. So we have been sending out these notice of penalty offenses to put companies on notice, in particular around practices relating to false earnings claims. There's been a lot of fraud in the for-profit education sector where companies have overstated the opportunities that students would have. We've applied them in the context of false earnings claims, including with gig companies that potentially may be overstating what drivers can be earning. So those are all tools that we're using, but 13B, no doubt, was a big loss for the agency and one where they're hoping that Congress will give back.
I think it's a very good discussion about remedies, because I can fully echo what both Lina and John just said, that we can only accept a remedy that is necessary in order to fix the concerns. So we don't have a policy of remedies, one over the other, but of course it must be something that we can actually see that is viable, that is sufficiently simple, very often structural, so that the loss of competition in a merger actually can come back. And it's not easy, which is why we have, fix it first, standalone. We don't very much like mix and match. And of course, we're very, very happy and thankful for the feedback that we get from market participants when we market test. First, when we do the market investigation, eventually if we do a market test. But even in the best of cases of results of market tests, we do not shy away from our responsibility to assess whether a remedy will work or not. But of course, if we have a very positive market test, then of course our arguments will have to be so much better if we do not accept it. But I think it's a crucial debate to have what it is. I think in the many recent mergers, we have taken structural or quasi-structural remedies, but we need also to discuss what is a remedy in a digitalized world. How does it look like if data is the thing in question? As said, we have taken in the Amazon case a data remedy to have a data silo, so that Amazon Retail do not anymore have access to other people's data. Is that a behavioral remedy or a structural remedy? I think it's worth discussing and keep following what is that we have ahead of us. A different issue, because I think we are approaching the end of this.
A few more minutes, yes.
A few more minutes. If anyone has wondered what is about this wonderful red star balloon that I have behind me, first of all, there ought to be balloons at any ABA meeting.
Duly noted.
It's a great thing. Obviously, it's there first and foremost to celebrate the wonderful team that has set all this up, because it doesn't come from nothing, and it's really great that we can be here. But the second thing is that the color red signifies the need for more female leadership in law firms. The legal community is so much more diverse than it were 10 years ago. But if you look at the level of partners, oh my God, you have way to go. So red is to remind everyone that get it on.
Margareta, I will specifically take that message back to my managing partner, Debbie Reed, which will help her say that there's international support for everything we are trying to do.
Good. You are on the bright side.
Every now and then. Every now and then. So thank you.
Just real quick on this question of remedies, I'd be remiss if I didn't note that this is where the FTC's partnership with the states is especially critical, because even though we're not able to get money back for consumers, the states can in many instances, and so some of those partnerships have been key. We've also been pursuing industry bans where necessary, and we're really thrilled to get a court order that would have banned Martin Shkreli from the pharma industry. So we're thinking about injunctive relief, especially also when encountering recidivists.
Yes, and I'll just add, in addition to our fabulous work with the FTC, we have state disgorgement still available for us in many states. We have state civil penalties. But also, we also have criminal authority And so this week, in fact, we formed a criminal enforcement committee to help states work through those issues. And we'll be working with your procurement collusion strike force to make sure that all that money that has gone out to the states to build those road contracts is actually spent properly, and we don't waste that 20% overage of.
Thank you for mentioning our procurement collusion strike force, because it didn't come up in my opening remarks, but it is in many respects a leading light and a gem of the antitrust division. With so much money being spent on infrastructure, so much money government procurement, our procurement collusion strike force has been an innovative and extremely effective tool, and we're really excited to work with the states. I also wouldn't miss if I didn't mention that the relationship with the state AGs, I'm glad you raised this, Lena, it's so critical, and I think in front of this group it's really absolutely essential for you all to hear. We are co-equals, and state enforcement actually predates federal antitrust enforcement, and there are many states that have anti-monopoly principles built in as fundamental rights in state constitutions. And so when I think about state enforcement, to me it represents how the concept of antitrust, how the concept of anti-monopoly is so fundamental to our existence as a country and to our democratic ideals, and I think in federalism. And so in so many ways, state enforcement and our work with our state enforcement partners is a really, I think, a representation of that ideal and the importance to our country, our democracy, and our core values.
Well, thank you. And I will say that we have really enjoyed the Enforcement Summit earlier this week, where we got to work with our international counterparts. Yeah. We don't often get a chance to do it, but through our international task force, through our international subcommittee of our legislative committee, we are, through our recent Rising Star Award winner, Beatriz Marquez, monitoring what the CMA, what the EC are doing, and trying to get as many lessons from you as we can. You know, there's abusive dominance provisions in 2 states right now, again, borrowing from the work that the EC has done. So we're all working well together, aren't we?
Yeah, it's real.
Well, as always, we're left with so much more that we could continue, which means when we reconvene next year, and we will reconvene next year, there'll be a lot more progress to talk about and topic. 2 things before we finish, there's one official piece of section business. But before we do that, I want to thank our speakers for being here, for taking the time, for traveling. And the last piece of business is to close the 71st annual spring meeting of the Antitrust Law Section by announcing that later today, the report of the nominating committee will be online. So you will all see decisions made about the future leadership of this section. And officially, the last is to thank everyone who has come together. This is a great conference simply because we are all together. There's so many of us, and there'll be even more next year. So thank you all. Safe travels to those who travel. Thank you for being together. We will see you next year, if not before.